In your view, is it discriminatory if I, as a restaurant owner, decide that I want to see proof that somebody has had a vaccine?
Probably not, but it's not clear, and it's going to cost them 30 grand in legal fees to prove it's clear one way or the other. And that's why most restaurant owners and pub owners want law brought in to absolutely clarify the situation so it is clear. Do you want me to explain why?
Please.
Feel free.
Well, we've got discrimination laws that say you can't discriminate against people on grounds of age, on grounds of maternity, on grounds of their belief. And it's just self-evident that if you're going to allow people with vaccines past the gate, but shut the gate to those who haven't had the vaccine, that you're discriminating against younger people, at least at the moment, while younger people can't get the vaccine. Might change in 6 months, but for now, that's the case. Same with women who are pregnant, because women who are pregnant are being advised to be cautious about having the vaccine. So you're closing the door to women who are pregnant or have recently had babies. Likewise, those with strong beliefs about medication and about injecting anything into their systems, you're closing the door to them. And you've got to show, if you're a pub owner and you want to justify that sort of discrimination, because you can justify it if you've got a good reason for it, that you've got a really sound reason for closing the door to those groups of people. And the reason is essentially we want to impede transmissibility of the disease. But the problem with that is that it's not clear from the medical evidence that it does certainly completely impede transmissibility. So it's a slightly dodgy reason. And the other reason people give is, well, we just want to make sure that if someone gets the disease, at least they only get mild symptoms if they catch it in our pub. But the problem with that, of course, is that younger people are likely to have the milder symptoms anyway. So that reason unravels a little bit. So pubs are faced with the problem that in theory, they're probably going to be able to justify discrimination, but there is some doubt. And what they don't want to be in is the position where someone says, I'm suing you for injury to feelings, because there's no financial loss they'd suffer from shutting someone out. It's injury to feelings only. I'm suing you for injury to feelings, and the going rate for that's about 500 quid. Either pay me 500 quid or spend 30 grand defending the claim. And that's why pub owners want absolute clarity before they take a decision.
Can I just ask you quickly? Oh, sorry, Iain. I just want to ask you a quick question, Daniel. Is the primary question that it's not actually full legislation? So, like, if someone is discriminated on the grounds of race, gender, sex, or religion, that's very, very clear in the statutes. Whereas this, it's more ambiguous. Or is it that the fact that the Coronavirus Act itself gives that person or that publican the right to do that? Is it the Coronavirus Act?
Yeah, great question, Denise. It's not the Coronavirus Act, it's the Traditional Equality Act, the normal discrimination legislation.
Okay.
But the difference with the ones you're talking about, race and some others, is that you cannot justify direct race discrimination. If I say to you, you're not coming in my pub because you're black, I can't justify that. I'm not allowed to legally. It's just prohibited. With age discrimination, you are allowed to justify it. That's the difference.